Specifically, the court specifically excluded from the scope of its decision the type of inconsistent verdicts that occur where a guilty verdict on one count logically excludes a finding of guilt on the other. And I would argue vice versa. In this particular case, we have an indictment that relies upon an underlying felony for the felony murder, that being the aggravated robbery. As trial counsel, I can tell you that I remember at the close of the state's proof, motioning the court and having the aggravated robbery charge reduced down to an attempted robbery charge at that point in time. And when it went to the jury specifically had a question, which I'll address in my second issue on appeal, but specifically addressed the question of finding that count 3 as an acquittal. And I say that to say that they dismissed the underlying felony that is the basis for the felony murder. And this brings me to the review of several other jurisdictions that are also reviewed in the State versus Davis opinion, and would encourage the court to adopt as well, of course, which is the Alabama Supreme Court looked at this in a decision that the result of two positive findings of fact that cannot logically coexist. This is termed as legally impossible for the state to prove the elements of both crimes, which in this, it's a bit of a reverse because we have a negative and a negative. But I say that to say, looking at the elements, which is the most basic thing that we are taught to do as legal professionals, or legal practitioners rather, is to take the elements of an offense and apply those to our case. So in this instance, with no robbery, we can have no felony murder based on robbery, is the easiest and most simplistic way to look at it. Although this is certainly not an easy or simplistic case. I then turned to Iowa, which also has quote unquote outlawed inconsistent verdicts and saying that they must be set aside. Next, and I'll kind of get on with it a little bit, is a case that I found to be particularly instructive of this, which is Maryland, or a state rather. Maryland's High Court struggled with this decision, and in the Price versus State, they entered a very wide decision that said no inconsistent verdicts. Well, this came back and kind of bit them a little bit because it resulted in a lot of appeals and a lot of issues. So then they took another look at it in the McNeil versus State, and I'll read directly from that, and this is from the Supreme Court of Maryland in 2012. They state, verdicts where a defendant is convicted of one charge but acquitted of another charge that is an essential element, which is what we have here, of the first charge, are inconsistent as a matter of law. Factually inconsistent verdicts are those where the charges have common facts but distinct legal elements, and a jury acquits a defendant of one charge but convicts him or her on another charge. The latter verdicts are illogical but not illegal. However, we have the first of those two examples, which is illegal. So I would just go on to say that Iowa, Alabama, Maryland, Connecticut, Florida, Indiana, Massachusetts, Missouri, New York, North Carolina, and Rhode Island have all addressed these issues that present itself before your honors today, and have ruled that legally inconsistent verdicts cannot stand.
Ms. Fry, the state argues in their brief that you're asking for us to change the law in the state of Tennessee. You agree with that?
I would say that I'm suggesting that we take a look at the law, and we take a very in-depth look at the law. In this particular case is one that I think is ripe for this issue to be reexamined.
So you do agree that currently in Tennessee, inconsistent verdicts are valid under Davis and under Wiggin?
Well, under Davis, and so to answer your question, I don't think that Davis was directly on point with this. I think that Mr. Wallace's case is distinctly different in that Davis looked at inconsistent. We here are looking at mutually exclusive. Davis said that yes, inconsistent verdicts are acceptable, but specifically did not address mutually exclusive and verdicts that cannot stand due to lacking essential elements.
So
wasn't Davis a felony murder case?
Davis was it was, but there was an underlying, it differed from this case with the mens rea versus the essential elements of the case. That in Davis, there was a conviction for a reckless homicide, as well as I believe it was a second degree murder conviction and reckless homicide. And the way that I would differentiate the case before you today is that we have a felony murder that does not have the predicate underlying felony as a conviction. And there was no alternative theory that the state put forth. For instance, if the state had also pled that there was the first degree murder, felony murder on the basis of theft, and then the jury convicted of theft, they could then have the other predicate felony for the felony murder. I don't think I said that very articulately, but.
Thank you.
Very good. And so also, just to kind of go on the Davis matter at hand, I also researched the Dunn decision. The Tennessee Supreme Court used Wiggins to discuss the Dunn decision. And I would submit to your honors that this is also distinctly different from that in the fact that this is not looking to examine the jury's compromise or to go back in the jury room and get into the rationale. This is more of a legal argument that I would state is very, very driven based on the elements. And I know I'm saying elements a lot. However, I think that it's important to realize that the argument today is that there cannot be the felony murder because it does not meet the elements of what is charged. And just to address briefly, I did have a second argument for on appeal, and that was that the trial court erred in responding to a jury question without bringing the jury back into open court while responding to said jury question as required by Tennessee Rules of Criminal Procedure 30C. And this does tie in, I would submit to you that this does tie into the sufficiency of the evidence on the felony murder, because the question that the jury had related to wanting to have the robbery acquitted, wanting to make sure that that was dismissed and entirely dismissed. And it was, I would submit, it was a linchpin of the felony murder was that robbery charge. And the jury was so concerned, and I'm not trying to go into Dunn and Wiggins where I'm examining what they're doing in the jury room, but I would say that I do feel that that is is instructive of the fact that they wanted to ensure that the robbery charge was gone. And this is related to the error that I cited, is that the best practice is to bring the jury back in, read the question, and then answer the question on the record, which we did not have in this instance.
So when the court said, or the jury, their question was, the court has dismissed count 3. You take that to mean all the lessers that are encompassed within count 3.
I believe that that's what the jury intended. They requested that, we the jury agree with the dismissal and do not want to bring it back into effect. On count 3, if we wish that it stays dropped, do we need to consider in the document as not guilty? And I would submit to your honor that in my view, and obviously for the appellant, would strongly suggest that the jury was very concerned that indicted offense be dismissed.
I suppose you're right, Ms. Fry, about your argument here. How is your client aggrieved or prejudiced in this because he was acquitted on count 3? So let's suppose the trial court did make a mistake by not reading the instruction, the supplemental instruction to the jury. How is your client harmed by that?
Well, thank you for the question. In the matter at hand, I believe that it ties into the overarching overarching consideration with my prior argument relating to the felony murder and the acquittal. I think it may have been more instructive and perhaps cured what we're now here for today, which is the felony murder, as well as the jury question.
I believe you're about to get into your rebuttal time. We've asked you a lot of questions, so if you want to take another minute and kind of wrap up, you can do that.
Well, I would, and I think that, and thank you for that, and the acknowledgement of my rebuttal time coming up quickly. I would just urge the court to examine this issue. It is an issue that directly looks at the existence of essential elements in determining whether or not there is sufficient evidence and evidence at trial level beyond a reasonable doubt for conviction. I would ask the court to consider that today. And at that, I'll close and allow my rebuttal time to address Mr. Watkins. Thank you.
Thank you. General Watkins.
Good morning, Your Honors, and may it please the court. Austin Watkins appearing here on behalf of the state of Tennessee. In this case, Your Honors, binding precedent precludes relief of the defendant from the jury's inconsistent verdicts, and the trial court's failure to read its answer to a question from the jury was harmless error at most. Therefore, the judgment should be affirmed. Your Honors, turn to this first issue of the sufficiency of the evidence / inconsistent verdicts. The state's position is very straightforward. In Tennessee, all forms of inconsistent verdicts do not entitle a defendant to relief unless there is legally insufficient evidence under the Jackson standard to support one of the verdicts. And that's not what we have here. In 2015, in State versus Davis, the Tennessee Supreme Court looked at a similar issue, although that case is factually distinguishable in that there wasn't an acquittal on one charge and then a conviction on another.
Does that matter? Would it make a difference as far as your argument goes if this had been after a jury verdict versus a judgment of acquittals? Let's say that the judge had dismissed count 3 in total.
If the judge had dismissed count 3 in total, I don't know how the trial court could have dismissed the predicate felony as having insufficient evidence and not somehow also dismiss count 2, right? Because the judge would have done the logical thing rather than say, oh, well, there's not enough evidence for the underlying felony, but there is enough evidence for the felony murder, which also requires the finding of the underlying felony. I don't think there would be a situation where the trial court would make the same error. But the factual distinction from Davis that I was trying to address is the jury here reached a full acquittal on one count. So the attempted aggravated robbery, which was the remaining predicate felony after the court's partial judgment of acquittal, the jury said, well, we acquit the defendant of all of the attempts. We completely acquit him of count 3. But we do convict him of the felony murder. That's different than what happened in Davis, where there were 2 felony murder charges. And I believe the premeditated charge, the jury rendered a verdict of second-degree murder. And then on the felony murder charge, they rendered a verdict of reckless homicide. So one of their verdicts was not an acquittal, but the state's argument is that there is no distinction for legal purposes in Tennessee. The Davis opinion does a survey of a lot of different inconsistent verdict cases from other jurisdictions, and it notes that some other courts have made a distinction for inconsistent verdicts versus mutually exclusive verdicts or logically inconsistent verdicts. And the gist of Davis is they're all inconsistent verdicts. It specifically refers to this situation, which was not the fact pattern in that case, but it acknowledges that an acquittal of a predicate felony with a conviction of the felony murder in Tennessee has for a long time and is still considered an inconsistent verdict, and there is no relief for the defendant, assuming there is sufficient evidence to support the actual conviction. And so in summary, the state's position is that Davis is very clear that there's just one term of inconsistent verdicts in Tennessee, and for all inconsistent verdicts, there is no relief unless the defendant can identify some other error, such as lack of sufficiency of the evidence. And so the state completely respects the appellant's attempts to try to distinguish this case and try to make some policy arguments for why the inconsistent verdict doctrine maybe should be revisited. But under Davis, this court should follow that opinion. And if the Tennessee Supreme Court's interested in it, then it should be the one to kind of reconsider whether there is a reason to change the law on this. And the state's position is that this is a good law. It's a very clear rule that is easy to follow for the appellate courts and the trial courts. And its reliance on some of the older Supreme Court of the United States cases, such as Powell and Dunn, provides a very sound rationale for this rule, which is it's not wise for us to try to meddle in the jury's reasoning. And it's unclear in most situations, I believe the term was whose ox is being gored. And so it's kind of one of those situations where rather than try to figure out was the error, because there is clearly an error in that the jury in some way did not follow the jury charge as it was instructed. Did the error benefit the state, or did the error benefit the defendant? And the rationale is just to let that lie and let the jury kind of just issue its verdict. And so unless there's some other reason to overturn a verdict, the Supreme Court of Tennessee has said there's just no relief that can be had here. Moving, Your Honors, if there are no questions on that, to the second issue regarding Rule 30 of the Rules of Criminal Procedure. There was a jury question in this case that was submitted during deliberation, and it was on the count 3, which was the freestanding charge for the predicate felony. And the jury essentially seemed to be affirming the motion for judgment of acquittal ruling, which was not what it had been instructed to do. It had been instructed to deliberate on the remaining lesser included offenses. And so when it returned that question, the trial court sent a written response back to the jury, which essentially reiterated its prior jury instruction that it had to consider those remaining offenses and that it had to complete the verdict form. And that's what the jury did, and they acquitted the defendant on all of the charges before it. And so what Rule 30C says is that for final jury instructions that they have to be in writing and that they have to be read aloud to the jury. This court has applied Rule 30C to supplemental jury instructions and answers to jury questions that come up after the formal jury charge, and said that even these answers and supplemental instructions, they need to comply with Rule 30 as well. The state, if you look carefully at the law, suggests that there's not necessarily a Rule 30 error when, rather than adding to the jury charge, in other words, rather than giving some information to the jury that was not within the original jury charge, it's not error for the trial court to simply reiterate what it already instructed in writing and aloud to the jury. And that was essentially what happened here. So the state would contend that there's not any error, but the easiest thing for this court, honestly, is that there's no prejudice. The defendant cannot show any harm here where he was acquitted of the count for which the jury referred to. And so appellant has tried to kind of dovetail that back into the felony murder conviction and say, well, if the jury had a question about the underlying predicate felony, then maybe they didn't understand the felony murder conviction or some instruction with regard to it. But the trial court's answer wouldn't have muddied the waters in any way or affected the jury's verdict on the second count, which under the sequential jury instructions, the jury should have already reached its verdict in count 2 on felony murder before it had even proceeded to the freestanding charge. So all of that should have been done in advance, and there's just no relief. There's no better relief for the defendant than the acquittal that he received in the trial court. So, Your Honors, I'm happy to take any additional questions on either of these issues, but if there are no further questions, the court would ask you to affirm the judgments.
So if I understand your argument on the jury instruction issue, Mr. Watkins, is the state's position is if it's something that's already been told the jury and the trial court just reemphasizes that section of the charge, then that doesn't need to be does not need to comply with the rule that says shall be in writing or shall be given orally. Is that what the state's position is in all cases?
The state's position is that Rule 30 has already been complied with. So shall does mean shall, Your Honor, but the reason this is different is if the court is not adding anything, it is merely in either reiterating in writing without saying it orally or saying it orally without saying it in writing. It is simply reperforming something that it has already done fully in compliance with Rule 30. So the state's position would be if it is not adding, a new definition, there's not.
I mean, that's what we had in Brewer, I believe, was the trial court failed initially to tell the jury some definitions. I want to say mental states.
I believe.
And then came back and did that not on the record. And as I recall, I don't believe the state even challenged that on Rule 10. Is that correct?
That's my understanding, Your Honor, yes. And that would be distinguishable from the rule that I'm advocating at this point, which is if the court is going further and is giving a jury instruction for the first time is in its supplemental instruction, then sure, that should comply with Rule 30. Yes, Your Honor. However, if it is merely reperforming an act that it has already performed in full compliance with Rule 30, then the state's position is that that's not actually a technical error with Rule 30. And the reason being that the jury has already gotten that information. It has already received the answer to its question previously, orally and in writing. And I guess the case law shows the concern with why it's important to make sure it's, in both forms is that all of the information gets to the jurors, that every juror is instructed, given the full and complete set of, jury instructions, and the court in the past expressed concern for someone who might be illiterate or maybe hard of hearing. Like it just wants all of the information to be conveyed in both manners, and that's understandable. But when it has already been done and nothing is being added, there's no risk that a juror or multiple jurors would have somehow missed something. They've been given all the instructions when there's nothing being added. And so that's the state here or the state's position here, Your Honor. And I did want to just briefly point out, if there is an error in some form, the Supreme Court in the Gorman case has said this is an error that is amenable, to harmless error review under the Rule 36 preponderance standard, right? So this is not a constitutional error where harmlessness has to be shown beyond reasonable doubt. It's just more likely than not. And I believe we cited several cases that show when there's kind of a technical violation rather than a substantive violation of the rule, so to speak, courts have found harmlessness to apply. And I think in this particular case, I just don't know what relief this court could afford to the defendant. Thank you very much, Your Honors. Judge Ogle, do you have a question or?
I just want to make clear that I understand that the state's position is there was no error.
That's correct, Your Honor, that there was no error. But if this court were to determine there was an error, that even the mere recitation of facts for the second time or an answer from the jury charge a second time must also recomply with the rule, the state's position is that any error was harmless under Rule 36.
There's an argument that these type of situations are exactly why we have this rule. So there's not a confusing situation that we arguably have here.
Yes, Your Honor. The jury instructions should be as clear as possible, and the purpose behind the case is interpreting application of Rule 30 to all jury instructions and answers to jury questions is to ensure that the jury has the highest chance of getting its verdicts right. That it is complying with the jury charge and all of its supplemental instructions when it is performing its deliberations, and the state understands that. But when there's nothing being added and the jury is simply maybe asking clarifying question, and the court simply says, well, in here, however, as instructed, you are, and so the court is reiterating, like, I've told you the answer, and let me say it very succinctly for you again, and then sends the jury back, even if it's just in writing and not done in court. The cases say ideally it'll be done on the record and done orally, and the state doesn't contest that would be the ideal way to do it. I think in recognition of the practicalities of trial courts who have to make decisions, and I think in the motion for new trial hearing, this judge pointed out, hey, look, this was an administrative question. They just needed to know, they were kind of confused about what the impact of the judgment of acquittal was. Do they need to complete a verdict form for count 3? And I basically told them, yes, deliberate on the charges I gave you for count 3, fill out the form. And my practice is to just dispose of that with a written question rather than call everybody back. And so that's understandable. The court the state sympathizes and understands that concern and is asking, when there's not additional information being provided to the jury, that there's no need to re-comply a second time with Rule 30, and that at most any error is going to be harmless given the fact that, again, in this particular case, where it's not a situation where there was a jury question and then the jury, there was arguably a failure to comply with Rule 30, and then there's a guilty verdict that comes back. This defendant was acquitted on this count. So he got as much relief as this court would be able to afford him with regard to this charge. And there's just no reason to think that he would be entitled to a new trial on any of the other counts, which already should have been deliberated upon by the jury before they raised their question with regard to this final count. Thank you for your time, Your Honors.
Thank you. Ms. Fry, you have your 3 minutes rebuttal time left.
Very good. Thank you. Just to address a few areas of concern that General Watkins highlighted, specifically just going back to the State versus Davis opinion and how this is differentiated from that opinion. I would reiterate to Your Honors that this is not a matter of inconsistent verdicts. This is a matter of mutually exclusive verdicts, which have been found to be troublesome in other courts and have been errors in other courts, as well as the policy directives to make sure that legally inconsistent verdicts do not occur. Just relating back to the second matter in regards to the jury instruction, General Watkins is right. I am dovetailing that issue into the bigger issue at hand, which is the error that was when the jury returned a verdict that eliminated an essential element of the felony murder charge. I think that those two go hand in hand together. And at this point in time, I believe that I have gone through the bulk of the issues with this, and I would just urge the court to take a look at this as it relates to being different from the Davis case as well as the Powell case, and acknowledge that Powell and Davis both left open the door for scenarios such as this. And so I would ask the court today to reverse and dismiss the felony murder conviction.
Thank you. Counsel, thank you both for very helpful oral arguments. The court appreciates good arguments, and you gave us that today. That concludes the case, and we are ready for the clerk to adjourn court.
This honorable court is in recess until 11 a.m.
Thank you.